Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about the issue of appointment of vice chancellors and what is the major dispute between the central government and state government related to the same manner. So first of all, if you look at the context in which we are discussing today's issue, so recently the Tamil Nadu State Legislative Assembly has passed two bills. Both of the bills seek to transfer the power that is vested currently in the governor of the state as far as the appointment of vice chancellors of the 13 state universities are concerned back to the state government. And this change, or you can say this particular passage of bill has been explained by the current Chief Minister of Tamil Nadu, M.K. Stalin. He said that this requirement, the passage of this bill are required because governor is currently disregarding the state government's opinion as far as the appointment of vice chancellors are concerned. Now, this is not the first instance when the state government has actually shown their displeasure against the decision of the governor as far as the appointment VCs are concerned. Similar argument has also been made by several states in the past. Notable of these are the Maharashtra and West Bengal. So what is the main issues? So as of now, as far as the appointment of vice chancellors, appointment of we can say vice chancellors of universities in the states are concerned, we do not have any uniform rules, uniform laws. So there is a large scale variations, wide variation across different states. Due to this wide variations, the interpretations are much more open for dispute, that what is the power of governor, what is the recommendatory power of a state government, whether the recommendatory power of state government supersedes the discretionary power of a governor. So all these things are very controversial and thus open for dispute due to lack of uniform principles and guidelines. And this becomes much more, we can say, though differences are everywhere in all the states, but these differences becomes much more intense whenever as the governor is appointee of central government, and if there is a sharp political differences between the central government and state government, then such problems can be exacerbated. So that is what is going on currently in Tamil Nadu, as the central government and state government belong to two different political parties having wide variation in their ideologies and their principles. So what does this bill that has been passed by the Tamil Nadu Assembly says? So the first important provision of this bill is that the state government will set up a panel, and this panel will then recommend three names, and these three names are the one through which from which the governor will have to appoint the vice chancellor. Earlier governor has discretionary power, so this power will be curtailed, and this panel of three names will be given by a committee that is called as a search cum selection committee that will be set up by the state government. And finally, it also make one other important provision that if need arises, state government will have the final word on the removal of vice chancellors. Even if governor does not want to remove the vice chancellor, but the state government, if they deem fit, can remove the VCs in certain instances. Now, how the removal will be done? So removal will not be again discretionary or on the whims and fantasies of the state government. The bill says that if a removal is to be conducted, the inquiry against the reason behind the removal will be conducted by the retired High Court judge, or at least those bureaucrats who have served at least as at a post of chief secretary. So the panel headed by either retired High Court judge or a retired bureaucrat who has served as chief secretary will be the one who will head the inquiry, and on the basis of the recommendation given by this particular inquiry committee, the state government can remove the vice chancellor. Now that is about the Tamil Nadu. What about the problems and issues in the other states? So one other major changes that has happened came from the state of Maharashtra as far as the governor's vice chancellor appointment power is concerned. So earlier they have this act, Maharashtra Public Universities Act, that was amended in year 2016. The original act actually did not give any power to state government as far as the appointment of VCs are concerned. However, as per the amendment, it is now the state government will have responsibility to suggest two names to the governor, and the governor can appoint vice chancellor by selecting either of the two. So it is kind of limitation on the governor's power, and this increase in the power of the state government for appointment of VCs. Similarly, Another significant event happened in year 2019 when the West Bengal government headed by Mamata Banerjee took away the power of governor as far as the appointment is concerned, and also they said that later they are planning to even remove the governor, who is the ex officio vice chancellor of the universities, and give that post to someone else from the state government or some other eminent personalities. Now here I want to put one more information, that generally it is the president who is the visitor of the state universities. However, the president has been given the power under the Central Universities Act that he can appoint anyone as a chancellor, and generally the governor, generally the president appoints governor as the ex officio chancellor of the universities. Now here the governor, when he is doing the work, when he is working or executing the office as a governor, he has to abide by the Council of Ministers and their advices. However, when he is acting as a chancellor of universities, he has a wide discretionary power and he does not have to necessarily abide by the suggestions given by the Council of Ministers, State Council of Ministers. Then another this controversy happened in the Kerala when we have a Kannur University, and here the governor actually said that as far as the appointment of vice chancellors are concerned, the governor said the Kerala government has disregarded his decision, that is for appointment of the same post. So these are the, in recent times, three important controversies that has happened between the state government and central and the governor. Apart from that, one of the incidents happened in Odisha also, where Odisha government was also trying to pass a bill where the appointment power of governor will be curtailed and a state government will suggest a list of the names through which the governor have to pick up the vice chancellors. Now, what are the main causes of differences? So, as if you look at the examples of states like West Bengal, Maharashtra and Tamil Nadu, what they basically says that they have problem because governor is not acting as an impartial, neutral we can say executive, but he is acting at the behest of the center on various subjects, and thus including in the areas like education, we are seeing a continuous tussle between the central government and state government. Similarly, the Tamil Nadu Legislative Assembly also have given the reasonal and rationale that if you look at the examples of Gujarat and Telangana state university laws, then on the basis of that also Tamil Nadu can pass similar legislation curtailing the power of governor. And third case comes from the states like Karnataka, Jharkhand and Rajasthan, where the concurrence between the state and governor are generally we can say suggested by the state government. However, this has not been mentioned anywhere in any rules or any legislations. So these are the three things on which the differences arise between governor and state government. So since we discussed in last slide that it is on the basis of Gujarat and Telangana state university laws, Tamil Nadu is trying to pass, Tamil Nadu actually has passed this bill. So what are these acts? So the Gujarat Universities Act 1949, it clearly mentions that vice chancellor of the state universities shall be appointed by the government, state government, from amongst 3 persons recommended by a search cum selection committee. So here also the power of state government supersedes the power of governor. Similarly, if you look at the Telangana Universities Act 1991, it also says that the search committee that will be appointed or that will be set up by the state government shall submit a panel of 3 persons to the government in alphabetical order, and the government shall then appoint the vice chancellor from out of the state panel. So taking examples from the Gujarat Universities Act and Telangana Universities Act, Tamil Nadu is also trying to pass a similar University Act. Now here University Grants Commission plays a very important role as far as the appointments and the standardization of universities is concerned. So let us try to understand about this. So education, it is in the concurrent list, that means both state government as well as central government or state legislative assembly or parliament can make rules and legislation regarding the same. However, it is the entry 66 of union list that clearly mentions that the coordination and determination of standards in institutions for higher education or research and scientific and technical institutions is under the domain of University Grants Commission, and it is in this context the power of central government supersedes the power of state government, and it is in this context we have to understand that UGC also exercises their power, because we have regulations that is called as UGC regulations 2018. that basically tries to standardize the quality of education across all the universities of India, whether it is a central university or a state university. At the same time, they also try to have a uniformity in appointment procedures at various important posts or key posts of the universities. And under this regulations 2018, they have mentioned that the visitor, that is generally the President of India, or the Chancellor, that is generally the ex-governor of the state, shall appoint the Vice Chancellor out of the panel of names recommended by the search cum selection committee. So as you can see, as we discussed before, now you will be able to understand, education is in concurrent list. The state legislative assembly as well as parliament can make rules over this particular subject. As per the some of the states I discussed before, Gujarat, Telangana and now Tamil Nadu, they have made a rule that the search cum selection committee will recommend the names to the state government and then the state government will appoint the Vice Chancellor. However, as per the UGC regulations 2018, it says that the search cum selection committee will recommend the names to the governor, who is generally the chancellor of the state, and then he will pick up the Vice Chancellor. So that is the area of conflict. So what does University Grants Commission, or how does this regulations of University Grant Commission is followed? So what we see generally all across the India, that if you look at the higher education institutions, especially those institutions which are receiving the grants from UGC, they particularly are mandated to follow the regulations, UGC regulation 2018. And most of the regulations of UGC are followed by central universities and large number of state university as well. But some places you see where the political differences come out due to the two different parties at the center and state helm, the state universities sometimes decline to follow the UGC regulations, and that is what we are seeing in the cases of Tamil Nadu. So obviously, since it is the matter of interpretation of laws, rules, regulations, the legislative powers of union and legislative powers of parliament and the state legislative assembly on the concurrent subject, we have to understand that what has been the stand of judiciary on this particular matter. So as per the Gujarat Universities Act, we know that the state government has to appoint the Vice Chancellor. However, last month the Vice Chancellor appointed to the Gujarat's SP University by the state government, the Supreme Court has put aside or set aside that particular appointment and have made some key observations. That is very, very important. So what are those key observations? The first observation that Supreme Court has said that any appointment as a Vice Chancellor, any appointment to the post of Vice Chancellor that is contrary to the provisions of UGC regulations can be said to be in violation of statutory provisions, and thus Supreme Court can issue a writ of quo warranto. So what is quo warranto? Quo warranto is a judicial power given to the Supreme Court where they can exercise and warrant a writ, and quo warranto basically means that if any person is appointed to any important or significant post, the Supreme Court can ask them that on what basis that person has been appointed, or on what basis, what is the reason, what is the rationale, what is the legislative provisions on the basis of which this particular person is exercising his duties or functions. And in that case, if Supreme Court deems that this exercise of power is being done in a nefarious manner, or we can say it is not in accordance with the laws and rules as well as constitution, then Supreme Court can actually remove that person from that particular post. So that is same thing can be done for the Vice Chancellors as well. If Supreme Court sees that the appointment of Vice Chancellor has not or has violated the statutory provisions, the Vice Chancellor can be removed. Apart from that, Supreme Court also has made this observation that every subordinate legislation of UGC flows from the parent act, that is UGC Act passed by Parliament in 1956, and therefore all the subordinate legislation passed under Parent Act UGC 1956 becomes part of the Act itself. So now as we can see, the UGC has passed a resolution that is in 2018. So if some state are violating the UGC regulations of 2018, that means they are also seen to be violating UGC Act 1956. And since if the state government are violating the UGC Act 1956 under the rule or principle of repugnancy as enunciated in Article 254 of the Constitutions, the state laws can be considered or deemed as null and void. Now this is very, very important provision. So we have to understand what do we understand by the term rule or principle of repugnancy in the Article 254. So in the Article 254, the doctrine of repugnancy is clearly stated. it becomes applicable when the matter or legislative matters are in the concurrent list, because in concurrent list, since union as well as state both can make the laws, so in such cases, if any part of the state law is repugnant or in conflict with any part of the central law which the parliament is competent to enact, in that case, to any part of law of the matter of list 3, that is concurrent list, then the central law made by parliament shall prevail. Here we have 3 lists. I think all of you know about that. We have union list, we have state list, and we have the concurrent list. So union list prevails over state list as well as concurrent list both, and concurrent list similarly prevails over the state list or laws made under the state list. So under the doctrine of repugnancy, if there is a conflict between the state laws and the parliamentary laws, the state laws will be considered null and void and parliamentary laws will prevail. So what we can understand in future, that even though Tamil Nadu is able to pass the bill and this matter is referred to the Supreme Court, then under the doctrine of repugnancy, Supreme Court can take the decisions as the Tamil Nadu's laws are violating the parliamentary laws, thus Tamil Nadu's law regarding the power of appointment vice chancellor can be considered as null and void. So that is all about this particular issue. I hope you understood about this whole tussle that is going on between central and state government regarding the appointment of VCs. Thank you very much.